I am Bergen County Surrogate Mike Dressler. As you have worked hard, worried over, and sacrificed for the future of your loved ones, it should be you, and not the laws of intestate succession, that decide the distribution of your estate. When assets are held individually, it is important to consider drafting a last will and testament. One of the things you can do within a last will and testament is choose your executor. That's the person you've chosen to oversee the operation of your estate. Now, the good portion about this document is you have the unbridled ability to do whatever you want within it. So whoever you feel best qualified to act as your executor, you can appoint to that position. The main thing we do within a will is we distribute our property in any fashion you see fit. There are no restrictions on what you can do within your will with your money and property. So if you want a person to get a single item, a fixed amount, a percentage, or the entire estate, whatever you want to accomplish through your will, you can accomplish. Before I became surrogate, I practiced law. And I'd say maybe 95% of the people who came to see me about a will wanted to create a husband and wife situation. That's one in which everything the wife has goes to the husband, everything the husband has goes to the wife. If both parents died and they had children, it would go to the children after that. And most people expect a scenario very close to that to take place when they die. Well, it's not necessarily true. If you die in the state of New Jersey without a will, the laws of intestate succession come into play. And what they are, they're very specific tables that indicate who will have priority in being appointed the administrator of your estate, and it may be someone that you don't want in that capacity. It also indicates where the money and property from your estate is going to go. And it may indicate it's going to someone that you wouldn't want to get that money and property. But there is absolutely no discretion. Whatever those tables indicate, that's where the money and property will go. Now, I'll give you a case in point to show you what could happen. In fact, it happened in my office a while ago. I had an attorney come in one day, doesn't do estate work, does criminal work. A friend of his had died, and he was helping his friend's wife go through the administration of the estate. So he came in for some pointers on how to go about things. We sat down, we talked for a while. First question I asked him was, what was the approximate value of the estate? He told me it was somewhere between $12 and $15 million. I asked him, under the terms of the will, who was going to be the executor, and again, under the terms of the will, where was the money and property going to go? He told me that there was no will. Well, because there was no will, these laws of intestate succession came into play. There were no children born in the marriage, and those laws of intestate succession indicated in this particular case that the wife in the matter got just 50% of the estate. The other 50% went to the gentleman who died's father. So because her husband never drafted a will, this woman was out $7.5 million. So you can see it can become very expensive if you do not have a will. For more information on wills, contact my staff at the Bergen County Surrogate Court today. Thank you.